The next topic I'd like to discuss are reentry obstacles to democratic participation. And I'd like to focus on three forms of democratic participation: voting, running for office, and jury service. Now, fortunately or unfortunately, many of your professors will focus some class time, sometimes an inordinate amount of class time, on their own research interests. Well, I'm guilty of that in this lesson. We are going to focus on obstacles to jury service. We are going to focus on what's commonly known as felon jury exclusion in some depth. Now, before we do, I just want to say a note about voting and running for office. Only 3 states right now still permanently exclude convicted felons from the electorate: Iowa, Kentucky, and Florida. Now, if you recall in 2000 in the contested presidential election between eventual President Bush and Al Gore, Florida and its felon population was noted quite a bit in popular news outlets. Now, restrictions on voting for convicted felons or those with a felonious criminal history are the sort of, quote, sexy restrictions that we hear about a lot every national election. You read an article about convicted felons and their restrictions on running for public office by Andrea Steinecker. Know that most of the restrictions on running for public office are tied to voting restrictions. So one is able to run for office if one is able to vote, and vice versa. Now, felon jury exclusion has been my research interest for the past several years. And it became my interest when I realized that all the attention regarding obstacles to democratic participation was given to voting and in many cases running for office. Now, felon jury exclusion breaks down this way jurisdictionally. In 27 states and in the federal system, convicted felons are excluded for life from ever serving on a criminal or civil jury. In 13 states, a convicted felon must complete his or her sentence, meaning a term of probation or parole also. Now, notably, this disqualifies anyone who maybe doesn't do prison time, but is given a sentence of straight parole or straight probation. In 2 states, a convicted felon can be challenged for cause for life, meaning an attorney can move to challenge for cause a convicted felon in the veneer, and that convicted felon will be excluded based solely on his or her felony conviction. No other characteristic need present. Now, in 7 states and in the District of Columbia, there are hybrid restrictions. And what this means is that the restriction is based on typically the charge type or the crime type, a term of years. So I'll give you 2 examples. In Colorado, a hybrid restriction, convicted felons are allowed to serve on petty juries, or a jury of 12, but are not allowed to serve on grand juries. In Washington, D.C., convicted felons are allowed to serve, but only after 10 years has expired from the end of the sentence that they have been given. Now, the way that felon jury exclusion statutes are structured is quite typical of any reentry obstacle or any statute that takes into consideration a criminal past. Most obstacles to reentry or most restrictions based on a criminal record are categorical. They typically say if you are a convicted felon, you cannot do X, Y, or Z. So it applies to all types of felonies. In some instances, violent felonies will be broken out, but in many, it's felonies across the board. Typically also, such restrictions will apply to all types of cases. In this case, what that means is that civil and criminal cases are treated the same. In the employment context, it may mean that a certain number of jobs are all treated the same. Meaning that for felon jury exclusion statutes that say permanently exclude, and California is a permanent exclusion state, I will never be able to serve on a jury in California, all felons in all types of cases are excluded from jury service forever. Now, there are a few exceptions. Arizona makes a distinction between first-time offenders and repeat offenders. Nevada makes a distinction between violent offenders and non-violent offenders. Colorado, as we discussed, makes a distinction between petty juries and grand juries. And Oregon makes a distinction between civil cases and criminal cases. Now, the justifications for felon jury exclusion are pretty straightforward. The first is what has been termed the character rationale. And it's the idea that if we allow a convicted felon to serve on a jury, that they will taint the process, or they will at least appear to taint the process, that those looking at this jury process from the outside will see it as somehow illegitimate because we have allowed a convicted felon or a number of convicted felons to serve. Courts and lawmakers are unclear about how having, quote, a lack of character translates into not being able to do the job of a juror. But what seems to be clear is that it is this taint or appearance of taint that we're concerned about. Now, the other rationale for felon jury exclusion is the inherent bias rationale. And this is more precise than the character rationale. The inherent bias rationale holds essentially that if we were to allow a felon to serve on a jury, that he or she would harbor a pro-defense pretrial bias and an anti-prosecution pretrial bias, meaning that the concern is felons would hang every jury they're on. Now, in civil cases, this makes little sense, but in criminal cases, we can see how this inherent bias rationale is on its face logical. Now, when we look at the justifications for felon jury exclusion, what we see is that those justifications make several presumptions about convicted felons, about felon jurors, and about non-felon jurors. And really, these presumptions hold across other obstacles to reentry or across other record-based restrictions on behaviors. What we see first is that categorical exclusions based only on a felony conviction assume a level of homogeneity among, in this case, felon jurors, and really felons generally. The idea is that all felon jurors or all convicted felons harbor some sort of bias against the system or lack character in a way that would somehow taint the deliberation process or the jury process. What we see is that felon jury exclusion and exclusions in general based on someone's criminal record assume that people with a criminal record are the, quote, others, that felon jurors are somehow fundamentally different from non-felon jurors, or that felons are somehow fundamentally different from non-felons generally. And like I said, you'll see this with a lot of record-based restrictions. Many record-based restrictions are not calculated, are not honed into the problem they're trying to solve. So what we see then are legislators and courts talking about record-based restrictions in this way. Well, all felons can't do X, Y, and Z, or all misdemeanants can't do X, Y, and Z, or all violent felons can't do X, Y, and Z. There are rarely individualized restrictions on the behaviors of convicted felons or misdemeanants or anyone else with a criminal record. So when you see these restrictions, what you'll see is this sort of blunt tool to eliminate those with a criminal history from certain aspects of society. And felon jury exclusion is no exception to that. Now, I just want to call your attention finally to some of the prior research on felon jury exclusion, because I think it's eye-opening when we think about record-based restrictions. The seminal research on felon jury exclusion was done by Brian Kalt, a law professor at Michigan State. Now, he wrote a theoretical article where he identified the justifications for felon jury exclusion and posited that, in fact, these restrictions maybe were both over-inclusive in that they eliminated convicted felons who didn't lack character and didn't harbor a pro-defense bias, but also were under-inclusive in that they didn't take into account non-felons who had some of the, quote, bad qualities that we're trying to eliminate from the jury process. Now, like many restrictions on convicted felons' behavior and on those with the criminal records behavior, there's little empirical research on felon jury exclusion. In fact, the bulk of empirical research done on felon jury exclusion, and again, this is in no way to be arrogant, I'm just giving you a fact, I have done in the last few years. Now, one of my colleagues, Professor Wheelock, did do some empirical research early on this problem. And what he found was that in Georgia, felon jury exclusion statutes that eliminate anyone with a felony conviction permanently actually racially homogenized juries. It made it so that there were fewer black men seated on juries in Georgia than otherwise would be the case if convicted felons had a temporal or non-permanent exclusion, that the permanent exclusions actually really racially homogenize the juries. One of the effects that he found was that in some death penalty cases or in death penalty cases in some counties, it lowered the number of African American males likely to be on the jury from 2 to 1. And this is significant because research tells us that when more than one African American male is on a jury in a death penalty case, that those verdicts and those then sentencing phase juries can decide quite differently. The research I've done on felon jury exclusion has focused on the justifications. In my first study that I did on the inherent bias rationale, I compared non-felon jurors, just a group of typical jurors, to a group of convicted felons to a group of typical jurors enrolled in law school or law students. And what I found was that, in fact, this inherent bias that we assume among convicted felons, that it wasn't as severe as presumed. And that, in fact, another identifiable group of potential jurors, law students, harbored a more pro-defense bias than did convicted felons, which begs the question. If we eliminate convicted felons permanently from the jury pool based on the inherent bias rationale, ought we not eliminate other groups of jurors who demonstrate the same or a more severe form of bias? Now, in terms of the impact of these restrictions, some of my recent empirical research looks at, and we're going to get into this later in the class when we discuss desistance, criminal desistance, and reentry. My research recently has focused on one state that places no restriction on convicted felons' opportunity to serve as jurors. There's only one state in the United States that does not have a statute regarding those with a criminal record and those serving on juries, and that's Maine. And in Maine, theoretically, someone could be taken from their jail cell in handcuffs and put on a jury. Now, that doesn't happen because of logistical purposes and security purposes, but given their statutory structure, it absolutely could happen. Now, in Maine, I interviewed approximately 40 convicted felons who had either served on a jury or had been called and dismissed or were simply just eligible for jury service and knew it. And what I found was that being on a jury really meant a lot to these men and women, that being able to serve meant a lot to them. They felt as though it was an affirmation that they had changed, that the state trusted them. And what we'll see when we talk about criminal desistance is that this can have an incredible impact on one's personal narrative and how one views their life going forward after a criminal conviction. So those are just some brief words about felon jury exclusion and how this all works. But I want you to think about this, and I'd like you to post a little bit on the discussion board about this, about how felon jury exclusion, how we can learn from this research. How we can look at some of the other restrictions that are out there, perhaps ones we haven't talked about in this course that you know of, and how they operate in many of the same ways. Because many do. Many are categorical. Many apply to all instances of conduct without being individualized, without being curtailed in any way. And I want you to just give some thoughts about what that means in terms of how we view convicted felons and how we view the behaviors that we don't want them to engage in, and how it may impact reentry.